State of Wisconsin versus Brendan Dassey, continued. Day 1. Count 3 charges the defendant with first-degree sexual assault by use or threat of a dangerous weapon, also as a party to a crime. Section 939.05 of the Criminal Code of Wisconsin provides that whoever is concerned in the commission of a crime is a party to that crime and may be convicted of that crime, although the person did not directly commit it. The state contends that the defendant was concerned in the commission of the crime of first-degree sexual assault by either directly committing it or by intentionally aiding and abetting the person who directly committed it. The person intentionally aids and abets the commission of a crime, then that person is guilty of a crime as well as the person who directly committed it. Person intentionally aids and abets the commission of a crime when acting with knowledge and belief that another person is committing or intends to commit a crime. He knowingly either assists the person who commits the crime or is ready and willing to assist, and the person who commits the crime knows of the willingness to assist. To intentionally aid and abet the crime of first-degree sexual assault, the defendant must know that another person is committing or intends to commit the crime of first-degree sexual assault and have the purpose to assist the commission of that crime. Before you may find the defendant guilty of first-degree sexual assault as a party to a crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant directly committed the crime of first-degree sexual assault or intentionally aided and abetted the commission of that crime. All 12 jurors do not have to agree whether the defendant directly committed the crime of first-degree sexual assault or aided and abetted the commission of that crime. However, each juror must be convinced beyond a reasonable doubt that the defendant was concerned in the commission of the crime in one of those ways. First-degree sexual assault, as defined in Section 940.225(1)b of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent and by use or threat of a dangerous weapon. Before you find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present. Number 1, the defendant had sexual intercourse with Teresa Halbach. Number 2, Teresa Halbach did not consent to the sexual intercourse. Number 3, the defendant had sexual intercourse with Teresa Halbach by use or threat of a dangerous weapon. This requires that the defendant actually used or threatened to use the dangerous weapon to compel Teresa Halbach to submit to sexual intercourse. If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree sexual assault have been proven, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be an innocent. The presumption requires a finding of not guilty unless, in your deliberations, you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you can better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Mr. Kratz, Juror Covington, were you able to hear me when I gave these instructions? Juror Covington, yes. The court, all right, let's proceed. Attorney Kratz, can everybody hear me okay? As our tech guy comes up here, I wanted to say good morning. Thank you for the service that you have offered in this case. you are from Dane County. You're not a Manitowoc County jury, and so it's a great inconvenience, I know, for all of you to sit and listen to this very important case. But let me assure you that this process, the process that you've been going in the next couple of weeks, may include one of the most important decisions that you're ever going to make. It is a daunting task for citizens to go through, but it is obviously important not just to Mr. Dassey, but to the Hallback family, to the friends of the family of Teresa Hallback, to the citizens of Manitowoc County, where we currently are holding this trial. The trial itself, or my opening statement itself, is not intended to be evidence. The judge already told you that, but it will be a little bit lengthy in that we have to take what maybe 6 or 7 weeks of testimony into a trial, and at least in this case, fit it into 3 days worth of testimony. And much of the evidence in this case is not contested, will be stipulated to, meaning agreed to, and so you, the jurors, since you don't have the same basis of knowledge that the lawyers do, you have to be told the background and a lot of those facts, and so I'll be doing that in my opening statement, as well as having some witnesses testify about that as well. You will notice around the courtroom are screens which do, in most regards, have the text or photos or the videotapes that you'll be watching. They are meant to assist you and give you different places to see those things, and so I wanted to encourage you to do that as well. Let me also remind you that this is not a closed system in that you can't participate. The one way that you can participate is if one of you needs a break for some reason. I need to let you know that if you need a break, either if you're not concentrating well enough or you just need a regular other kind of break, just raise your hand, all right? Get my attention or the judge's attention and we'll take a break. And certainly during this opening statement, you'll get at least 1 and perhaps 2 breaks so that you're able to remain fresh. You're able to listen to the very important statements that myself and the defense will be giving in this opening statement, all right? First thing I want to talk about is an introduction of the prosecution team. That is, the people that are sitting at or near this table. My name is Ken Kratz. It's the first chance I've had to address each of you. I am a district attorney. I'm the DA of Calumet County, which is the county just east of Manitowoc, just west of Manitowoc, where we are right now. And I am the lead counsel. Nothing special about that term. It just means that I have coordinated the investigation and prosecution of this case and will be assisting in the presentation of the case as well. Mr. Fallon, who you already heard from, is an assistant district attorney. Mr. Fallon works for the Department of Justice in Madison. He's the gentleman in the middle and will be another prosecutor in this case. And finally, Mr. Gahn is a Milwaukee County Assistant District Attorney. Mr. Gahn will be presenting the parts of the case, you'll notice, where Mr. Gahn has expertise. That is in DNA evidence and in the sciences and some of the other places. So I at least wanted to let you know why we're involved. We, by the way, are helping. We're doing a favor, if you will, for Manitowoc County. The 3 prosecutors that have been assigned responsibility for this important case and the case involving Stephen Avery, which were the same prosecutors, the same prosecution team, assisted Manitowoc in the efforts of the prosecution. 2 lead investigators were involved in this case. They are Mr. Mark Wiegert, who is the gentleman in the glasses. Mr. Wiegert is an investigator with the Calumet County Sheriff's Department. And Mr. Tom Fossbender, who is seated next to him, works again for the Department of Justice, Division of Criminal Investigation. You're going to learn in this case that several hundred law enforcement officers were involved, that the personnel and the search efforts in this case were overwhelming. In fact, you're probably going to learn that this was one of the largest, if not the largest, at least by resources, investigation, criminal investigation, homicide investigation in Wisconsin history. And because of the scope of this case, because of the size of this case, it required investigators to coordinate or to make sure that everything was done not only properly, but leadership and direction was certainly required in this case. If I could have just a minute, we're going to try to fix at least those 2 screens so that all of the text shows, but that doesn't mean I'm going to stop. I'm a lawyer, so I can just keep talking. Opening statements, as the judge told you, are an opportunity to tell you what we think the evidence is going to show. But more than that, it's a roadmap. It's an overview. Since evidence comes in bits and pieces, some people describe trials as puzzles, jigsaw puzzles, if you will, and how evidence may fit into there. You need to know how each little piece of evidence in this 2-week trial is going to fit into the big picture. Is going to fit into whether or not Brendan Dassey is guilty of the 3 offenses for which he has been charged. I've told you, and you know, and most of you, in fact, I think all of you have indicated in your questionnaires that you were at least somewhat familiar with the Steven Avery case. But you didn't hear the evidence in that case. And some of that evidence, as I mentioned, may or may not be contested, but because of the importance of this case, it's still necessary to tell you the whole story. It's necessary to explain all of the physical evidence, as well as the evidence that may be directed towards Brendan Dassey, and some of that evidence, again, will be physical evidence, and some is going to be statements. And so we intend to tell you about all of that, certainly, during this opening statement and during this process. The judge told you that Mr. Dassey's been charged with 3 separate offenses: first-degree intentional homicide, mutilating a corpse, and first-degree sexual assault. He told you the elements, that is, what it is the state has to prove, and we certainly intend to do that. All right, the first legal concept that I want to talk about is party to the crime. The judge has instructed you that party to the crime is a concept, a form of criminal liability that is committed either when somebody commits a crime themselves or when they aid and abet the commission of the crime. Now, this is the law. Judge Fox will tell you what the law is. So whether you think this is a good idea or a bad idea, it's the law and you have to follow this law. And so the description or the explanation of, as an example, what aiding and abetting means is important for you to know. The judge has told you that a defendant can aid and abet the commission of crime if he assists somebody who commits it, or, importantly, and what you might hear in this case, as the evidence may show in this case quite a bit, is that the individual, in this case Brendan Dassey, stood ready and willing to assist, and that the actor, in this case Steven Avery, was an individual who knew of Brendan's willingness to aid and abet. All right? Now, I'm telling you that this early in the case because this is an important concept. It's important for you to understand what the criminal liability is, and again, whether you agree with or don't agree with that concept, with the concept of party to the crime, it's something the judge tells you you have to accept and you have to adopt. I'm going to introduce you to a lovely young woman. This is Teresa Halbach. Miss Halbach was 25 years old on Halloween of 2005. You're going to hear evidence in this case that Miss Halbach was single, that Miss Halbach was a college graduate. Miss Halbach was a freelance photographer. She was a daughter. She was a sister. She was a friend, and she had her whole life ahead of her. You're also going to hear evidence that all of that came to an end on Halloween of 2005. This story, this case, begins at about 8:12 a.m. on Halloween day of 2005, when the plan was set into motion to take this young woman's life. The plan was set into motion to rape and to kill and to mutilate this 25-year-old innocent young woman. The investigation of this case begins when we learn that Miss Halbach was reported missing on Thursday, the 3rd of November, 2005. She was a photographer. One of her contracts, one of the reasons that she was a photographer, was she worked for a magazine. She worked for something called Auto Trader magazine, which was a magazine that sells cars. It puts ads in the cars, and it requires photographers to go around and take pictures of those cars. And so learning about Miss Halbach, or learning how she worked for Auto Trader magazine, is important for you to understand about the investigation, because you will learn that the investigation, or at least the missing persons investigation, determined that the last place that Miss Halbach was on the 31st was a place called the Avery Salvage Yard.